Salutations to all our future judges. In this video, we are going to see the Code of Civil Procedure 1908, Part 6, Sections 17 to 21A. Already, 5 parts have been published, and if you have not seen those 5 parts, I am providing the link of the playlist in the description. You can view all those 5 parts and then you can come to this part 6. And if you have not seen part 5, I am providing the link in the iCard. You can watch that as well. Now let us see section 17. Suits for immovable property situated within jurisdiction of different courts. Imagine a property is situated in a place where two courts have jurisdiction. For example, there is a court A and there is a court B, and this property lies in the border of these two courts, covering both the jurisdictions. Then in that case, where a suit with respect to that property can be filed. If it is a compensation for wrong, then where it should be filed. Then in that case, it can be filed within the local limits of jurisdiction where any portion of the property is situated. But the essential thing is that the value of the subject matter of the suit should also be taken into consideration. For example, if the A court is entitled to try cases up to 1 lakh and the B court is entitled to try cases up to 20 lakhs and the property value is 20 lakhs, then the case can be filed only in the B court and not in A court. This is section 17. Now let us move to section 18. If the suit property is situated in such a place that ascertaining the jurisdiction of the courts is difficult, then in that case where the case should be instituted or the place of institution of suit is to be determined when the local limits of jurisdiction of courts are uncertain, how it should be done. Now let us move to subsection 1 under 18. Imagine if there is a confusion with respect to the jurisdiction of a court as to where the case should be instituted or the case should be filed. If the property is situated in such a location where it is difficult to determine under which court's jurisdiction the property is situated, in that case, the case can be filed in any one of those courts. For example, if there are 3 courts which are expected to have jurisdiction with respect to that particular property, then in that case, out of those 3 courts, you can file in any one of the courts. And the court in which you are filing this case, if they are satisfied that there is a ground for alleged uncertainty, there is a possibility of uncertainty, they feel that yes, it is uncertain as to which court can entertain this particular case, then they can record a statement to that effect. They'll simply write that there is uncertainty with respect to the jurisdiction, and they'll state the reason as to why that uncertainty is there, and after that they'll proceed with the case and dispose the suit, and the court which is passing the decree in such a manner shall have the same effect as if the property was situated within the local limits of its jurisdiction. If this particular thing happens, there is another aspect which needs to be taken into consideration, and that is the suit with respect to the value. As I already explained, in some cases the courts have jurisdiction to entertain cases up to rupees 1 lakh, and in some cases 1 lakh to 10 lakh, and then above 10 lakh, and then above 1 crore. There are some pecuniary jurisdiction, and the suit needs to fulfill that criteria also. Simply you cannot go and say like, I am uncertain about the jurisdiction, you please take the case. That is not permitted. In addition to that factor, the pecuniary jurisdiction should also be there based on the value. And now let us move to 18 subclass 2. Imagine a situation where a person is confused with respect to the jurisdiction, and he goes and files the case in a court which he presumes to have jurisdiction, and there is uncertainty, and the opposite party, that is the defendant, does not raise an objection in the first instance. In that case, whether he can raise this objection in the appellate or revisional court, the answer is no. The statement with respect to the jurisdiction or objection with respect to the jurisdiction should be raised in the first instance. If someone fails to do so, he cannot employ this defense in appellate or revisional court. However, there are certain situations in which the appellate or revisional court can entertain this. The first thing is, when the suit was instituted, there was no reasonable ground for uncertainty. In that case, the appellate or revisional court can entertain this defense. The second aspect, there will be a failure of justice if this is not entertained, or there has been a consequent failure of justice. In that case also, the appellate or revisional court can entertain this objection. Now let us move to section 19. Suits for compensation for wrongs to persons or movables. If there is a movable or a wrong which is done to a person, compensation will be given in certain suits. Now we are going to see that in detail. If a person is filing a suit for compensation for the wrong done to the person or to a movable property, in that case, if the wrong was done within the local limits of jurisdiction of one court. Imagine there is a court A. Within that A court's jurisdiction, this wrong is committed. And in addition to this, there is one more condition which we need to add to this. And the defendant resides or carries on business. The defendant is residing in a place and is carrying on a business in a particular place, or he personally works for gain in that particular place within the local limits of jurisdiction of another court, say court B. Then the suit may be instituted at the option of the plaintiff. So the plaintiff can either file the case in court A or court B. Court A is place where the wrong was done. Court B is the place where defendant resides or carries on business or personally works for gain. In these two places, the plaintiff is entitled to file his case. Let us see the illustration which is provided here. Illustration A. A is residing in Delhi. A is a person, he is residing in Delhi. He goes to Calcutta and beats B, who is in Calcutta. Then in that case, B can sue either in Calcutta or in Delhi. Calcutta is a place where A beats B. So in either of these jurisdictions, one of these jurisdictions, either he can do it in Calcutta or in Delhi. Either one of these two. And now let us move to the next illustration. A is residing in Delhi, but he publishes in Calcutta a defamatory statement about B. Then B may sue either in Calcutta or in Delhi. He can either sue in Calcutta or in Delhi. Now let us move to the next section, section 20. The suits which are not covered in the earlier sections are to be instituted where the defendants reside or the cause of action arises. See, let us try to understand this in a simple manner. Imagine it is a very complicated case and the jurisdiction cannot be ascertained and it does not fall within the previous sections. In that case, it can be instituted in a court within the local limits of whose jurisdiction the defendant or each of the defendants when there are more than one defendant. You can file the case where the defendant resides or he carries on business or personally works for gain. Now let us move to the next subsection, that is 20 subsection B. If there are more than one defendants at the time of commencement of the suit, then any one of the defendant voluntarily resides or carries on business or personally works for gain. Imagine there are three defendants A, B and C. A is residing in Chennai, B in Delhi, C in Calcutta. There are three places. These defendants are residing in three different places. Then if a person is filing in Delhi, the person in Chennai and Calcutta will say, no, it is difficult for us. In that case, he has to obtain the leave of the court. He should obtain the permission of the court. Then he can file in Delhi or else he can file in Chennai or Calcutta, depending on the permission given by the court. Then subsection C. Now let us move to 20 subclass C, where the cause of action wholly or in part arises. So simple thing is, you see the cause of action. Even if a part of the cause of action is in a particular place, you can file a case in that particular place. Now let us move to the explanation which is given. So if there is a corporation, generally corporation will have a branch office and a head office. Generally, that is how a big corporation works. In that case, if there is a corporation and there is some dispute against this corporation, then the case can be filed where it is carrying on business in its principal office or where it is a branch office or a subordinate office. Let us move to illustrations. Illustration A. There is a person called as capital A. He is a tradesman who is in Calcutta. And there is another person B. He carries on business in Delhi. B, through his agent in Calcutta, buys goods of A and requests A to deliver them to East India Railway Company. So this B in Delhi is buying through his agent in Calcutta and directs the goods to be delivered to East India Railway Company. And as directed, A delivers the goods in Calcutta. Then in that case, if B does not pay the money, then A can sue either in Calcutta or in Delhi, where the cause of action arose and where B carries on the business. Imagine if B is not paying the price. Then A can sue either in Calcutta where the cause of action arises or in Delhi where B carries on his business. Let us move to the next illustration B. A resides as A is a person who is residing at Simla and B is a person who is residing at Calcutta and C is a person who is residing at Delhi. This A, B, C are friends. They travel together to Benares and there B and C make a joint promissory note payable on demand and deliver it to A. Then A can sue B and C at Benares where the cause of action arose, or he may sue them at Calcutta where B resides or at Delhi where C resides. But in each of these cases, if the non-resident, if the defendant who is not residing there is objecting, the suit cannot be proceeded without the leave of the court. So simply you need to get the permission if the other defendant is objecting to the jurisdiction. Now let us move to section 21. If somebody has to raise an objection with respect to the jurisdiction, when he should do. Now in 21 subsection 1, it says that a person has to raise his objection at the first instance itself with respect to the jurisdiction. If he does not do so, he will not be permitted to raise this objection in the appellate or revisional court. However, there are certain exceptions to this. If there is a failure of justice, if this is not allowed, in that case, appellate or revisional court can entertain the objection with respect to the jurisdiction. However, any objection with respect to the jurisdiction should be taken at the first instance and before the settlement of issues or issues are settled. Now let us move to 21 subsection 2 is with respect to the pecuniary jurisdiction of courts. If a court has got no pecuniary jurisdiction to entertain the case, that objection should be raised in the first instance. That is very important. At the earliest possible opportunity and in all cases where issues are settled at or before such settlement. You can do it before the settling of issues or at the time of settling of issues. However, an exception to the subsection is that if there is a consequent failure of justice, in that case, court can accept the objection with respect to the jurisdiction in appeal or revision. Now let us move to 21 subsection 3. With respect to the executing court, if there is any objection with respect to the jurisdiction of that executing court, it should be raised at the earliest possible opportunity. And if someone does not raise this objection at the earliest possible opportunity, he cannot raise this objection in the appellate or revisional court. However, the exception is that if there is a consequent failure of justice, he can be permitted to raise the objection in the appeal or revision. Now let us move to the next section, section 21A. Bar on suit to set aside decree on objection as to the place of suing. Imagine if there are two parties and already they have filed a case, they have obtained a decree. And if someone is trying to challenge the validity of the decree, then it cannot be done. Already a decree is given, you cannot challenge it. with respect to the fact that the place of suing is wrong. Simple fact is A and B are parties. A is filing a case against B. A succeeds in that case. Now B cannot go and file a fresh suit saying that the place of suing is wrong. And what is former suit? Former suit means a suit which is decided prior. The one which is decided first is called as former suit. It is immaterial as to when the subsequent suit is filed. Simple aspect is when the suit was decided is the deciding criteria. That should be taken into consideration as the point which is stated in section 21A explanation. If you like the video, please do press the thumbs up button and leave your comments in the comment section. And do subscribe the channel and also share the channel with your friends. Let us join hands together and contribute for a learned society. Thank you.